of the Social Health Insurance Fund Act 2023 constitutes a violation of Articles 201, 205, 2061 of the Constitution. The petitioner contends that the Section 38 of the Act, as currently enacted and significantly amended from the original bill, violates the principles of public finance as enunciated in Article 201 of the Constitution. These guiding principles of public finance encompass openness, accountability, public participation in financial matters, the promotion of an equitable society, the prudent and responsible use of public funds, and clear, responsible financial management and fiscal reporting. The petitioner accuses the National Assembly and Senate of breaching these tenets, first by failing to consult the Commission on Revenue Allocation, that is the Commission, before enacting the legislation as required under Article 205 of the Constitution. In response to this assertion, the Attorney General cited the case of Association of Gaming Operators Kenya and 41 others versus the Attorney General 2014 EKLR, arguing that the statute cannot be deemed unconstitutional merely because no recommendations were made by the Commission, even if the bill pertains to county governments. This position is reiterated by the CS. On its part, the National Assembly argues that the Commission had no role to play since the funds established under the impugned acts were not established for purposes of revenue sharing between the national and county governments or for financing of county governments. The monies in the funds were to be appropriated by the National Assembly, and as such, the report by the Commission was not required. Article 205, Subarticle 1 of the Constitution is categorical on the circumstances where the consultation with the Commission is mandatory. This is when, quote, a bill that includes provisions dealing with the sharing of revenue or any financial matter concerning county governments is published, quote. Without belaboring the point, there is written confirmation by the Speaker of the National Assembly that the bills and therefore the impugned acts concerns county governments. This is admitted also by the Senate. The question for determination, therefore, is whether the Commission's recommendations should have been invited. In what appears to be blowing hot and cold, the Commission, in its replying affidavit, starts by confirming that indeed the impugned acts contain provisions relating to financial matters of county governments. It proceeds to note that, as mandated in Articles 215 and 205 of the Constitution, quote, it ought to have been consulted for it to make its recommendations, which should have been tabled and considered by the 5th and 6th respondents before the enactment of the said acts. The 4th respondent was neither consulted nor its recommendations sought, and obtained prior to the 5th and 6th respondents passing the impugned acts into law, despite the said acts containing provisions dealing with financial matters concerning county governments, quote. However, in a sudden volte-face, the Commission, through its further affidavit, appears to contend that providing recommendations as envisaged in Article 205 of the Constitution is discretionary and not mandatory. Both the Attorney General and the Commission cite the decision in Association of Gaming Operators Kenya and 41 others versus the Attorney General, EKLR, in which this court held as follows, quote, in this instance, there is no indication that the CRA considered the Finance Bill 2013 and made recommendations. In the absence of such recommendation by the CRA, Article 2052 cannot come into play. In the absence of recommendation by the CRA, I do not think that the resultant legislation can be declared unconstitutional by reason of the CRA failing to discharge its duty to make recommendations on the Finance Bill 2013. I therefore find and hold that the Finance Act 2013 cannot be impugned on the basis of want of compliance with Article 205, quote. The Constitutional Court of South Africa, in certification of the Constitution of the Republic of South Africa 1996, dealt with the role of the Financial and Fiscal Commission, FFC, which is similarly established. It emphasized the importance of the FFC's role in providing expert recommendations to government. It also highlighted that while the recommendations of the FFC were advisory, they carry significant weight and must be seriously considered by the legislative bodies. More importantly, the Supreme Court of Kenya has had the opportunity to consider the role of the Commission and the implications of Article 205 of the Constitution. This was when it was approached for an advisory opinion on whether the Commission's recommendations are binding in the matter of the Council for Governance and 47 others 65 KLR. The Supreme Court pronounced itself as follows. Quote, "It is our considered opinion that where either of the two houses passes a bill envisaged under Articles 205 of the Constitution without considering the recommendations of the Commission or revenue allocation, the recommendation of the Commission on revenue allocation, the resultant legislation would be unconstitutional. It is our considered opinion that the recommendations by the Commission on revenue allocation are not binding upon either the National Assembly or the Senate. What the two houses cannot do, however, is to ignore or casually deal with such recommendations, quote. In simple terms, the Supreme Court of Kenya clarified that although the Commission's recommendations are not binding on either house, the input from the Commission is nonetheless an unequivocal prescription in Article 205 of the Constitution. This means that the Commission must be consulted even though it may or may not give a recommendation on the proposed legislation. Indeed, Article 205(1) is couched in mandatory terms, quote, when the Commission on revenue allocation shall consider those provisions and may make recommendations to the National Assembly and the Senate, quote. There is no evidence to show that the Commission was consulted or invited to make any recommendations on the three impugned legislations. Our reading of the advisory opinion of the Supreme Court is that contrary to the holding of this court in the Association of Gaming Operators and 41 others versus the Attorney General, the failure by either of the houses to consult the Commission on enacting legislation that relates to financial matters concerning county governments is unconstitutional. The consultations are crucial for informed decision-making and ensuring fiscal responsibility and equity. It was therefore quite imprudent for the two houses to reduce the Commission into a bystander in such critical pieces of legislation. The petitioner's other point of contention is the alleged breach of Article 2061 of the Constitution. This concerns the provision in Section 38 of SHIA that eliminates the requirement to return any unused funds from the Social Health Insurance Fund to the Consolidated Fund at the end of each financial year. The petitioner expresses dissatisfaction with the unilateral decision to substantially alter this provision after public participation had taken place, thereby preventing the public from discussing the section as it currently stands. He raises concerns about the potential for pilferage, misuse, embezzlement, open theft, and wanton pillaging, all occurring without accountability. The initial Section 38 under SHIA provided for investment of monies of the authority, which are not immediately required, in a reputable bank with the advice of the CBK or in government securities with the advice of the National Treasury. The current Section 38 is completely different. It reads as follows, quote, all receipts, earnings, and accruals to the authority and balance of the funds at the close of each financial year shall be retained by the authority for the purposes of the funds, quote. In the year responses, the Attorney General, the CS, the NA, and the Senate defended the omission of the initial Section 38 on the basis of Article 206, Subarticle 1, maintaining that the Social Health Insurance Fund was established under the Act for that purpose and that there is nothing unconstitutional with Section 38, since the Constitution under Article 2061 allows the same. Article 2061 provides as follows, quote, there is established the consolidated fund into which shall be paid all money raised or received by or on behalf of the national government, except money that A is reasonably excluded from the fund by an act of parliament and payable into another public fund established for a specific purpose, quote. We do not agree with the petitioner on the submission that the three funds established are ambiguous. We note that the Social Health Insurance Fund, the Primary Health Fund, and Emergency Care Insurance Fund are all established under Sections 25, 20, and 28 of the Act, respectively. Contrary to the view expressed by the petitioner, by dint of Section 5 of the Act, it is a function of the authority to manage the funds and to develop guidelines for the operations and implementation of the funds established under the Act. We, however, note that the operationalization of the specific sections is yet to be effected by way of regulations. We agree that there is reason for apprehension as expressed by the petitioner. This is so because the current section was introduced ignoring a key principle under Article 201A, which emphasizes on the need for openness, accountability, and public participation in financial matters. Further, the question that lingers in our minds is, why was the new Section 38 introduced without the benefit of public participation? The provisions of Article 201 of the Constitution must be understood and interpreted against a historiography of Kenyan society. The drafters of the Constitution were certainly intent in representing a departure from a past where public matters were preserved of closed dialogue in opaque rooms only rubber-stamped by Parliament. Section 38, in our view, therefore, fails the test under Article 201A of the Constitution and is therefore unconstitutional. We should point out here that we appreciate the effort of the CS in attempting to realize the socio-economic rights provided under Article 43. The effort is commendable. The research and the industry shown in coming up with the pieces of legislation is also commendable. The objectives and purpose of the impugned legislations were to have a progressive, transformative, and a huge impact in the realization of universal health care for this country. However, the haste with which they were enacted infringed on the national values and principles of the Constitution. Inasmuch as we appreciate the noble intention, we cannot disregard the clear constitutional tenets which binds us. Article 20 requires us to promote and protect the values that underlie an open and democratic society and the spirit, purpose, and objects of the Bill of Rights. Being cognizant of the importance of the impugned laws and the input that has already gone into the enactments, and recognizing the purport of the enactments as far as the realization of the rights under Article 43 of the Constitution, we are prepared to give Parliament an opportunity to redeem itself and save the laws. The breaches that tainted the laws are redeemable within our findings and can be corrected. Before we pen off, we wish to acknowledge the industry and input of learned counsel who appeared before us, and this is our disposition of the petition. Accordingly, we find that the petition is meritorious and we allow it in the following terms. A. Let Parliament undertake sensitization, adequate, reasonable, sufficient, and inclusive public participation in accordance with the Constitution before enacting the said acts and amend the unconstitutional provisions in terms of this judgment. B. Compliance with the A above be undertaken within 120 days of the date of this judgment. C. Within that period, the acts shall remain suspended. D. In default of A and B above, on the 10th day of November 2024, the following relief shall take effect forthwith. 1. A declaration is hereby issued that the entire Social Health Insurance Fund Act 2023, the entire Digital Health Act 2023, and the entire Primary Health Act 2023 are all unconstitutional for the reasons set out in this judgment and therefore invalid, null, and void. Since this was a public interest litigation, we order each party to bear own costs. That is our judgment. You will be able to get it. It will be uploaded. Sign. It will be uploaded by 2 p.m. this afternoon, and you can get it from the CTS, or if you want a copy, probably Mr. Kenya will be able to prepare for you. Thank you.
Thank you very much.